So we we return to the third lecture of Indian polity by M. Laximakam. Good morning to you all. So the topic that we s- that we are going to start is called the silent features of the Indian Constitution. So what are the features of the Indian Constitution? So India has a written constitution. It is the largest constitution. It has incorporated all the experiences gathered from the working of the non-constitution in the world, and the, they avoid all defects and loopholes that might be anticipated from the light of other constitutions. So in Indian constitution is a mixture of different types of constitutions. For example, the federal system of government with a strong central government has been adopted from the Canadian constitution, and the concept of judicial review and the parliamentary system of government was adopted from the United States Constitution, and the directive principles of state policy has been adopted from the Irish Constitution. So what type of constitution is our Indian constitution? So our Indian constitution is both rigid and flexible. It means that it, it, it can be amended and it can still be rigid in its original form. So it is rigid means there is a special procedure for amending the constitution. So for amending the constitution, we need a majority of both the houses in the Lok Sabha and the Rajya Sabha before making changes in the constitution. And flexible means it is an order means that with an ordinary procedure, some areas of the constitution can be amended. So the Indian constitution also uses the system of federal system. So it means that power is divided in between the center and the state. So and it is a parliamentary form of government. This form talks about the presence of nominal and real executive. The majority party rule and collective and the ministers in the Lok Sabha are collectively responsible to the Lok Sabha. This statement means that in case the majority falls, then and no confidence motion can be presented and the government can be dissolved. And the leadership of the prime minister and chief minister at the state level. And the dissolution of Lok Sabha. This type of government is present in both the central and the state level. So in case the majority falls, so the government can be dissolved. The fundamental rights. What are the fundamental rights? These are the promotions of political democracy. They are they, they are there are seven. There was earlier 8 fundamental rights, but the right to property was removed as a fundamental right and adjusted as a constitutional right. So there were originally 7 fundamental rights were mentioned in the constitution, though the 44th amendment, the right to property was deleted from the list of fundamental rights. Now only only six fundamental rights are mentioned. And the next is the DPSP, the Directive Principles of State Policy. They are established to they are seek to establish welfare of state in India. They are not justiciable, that means cannot be challenged in the court of law. But in the Minerva Mills case of 1980, the Supreme Court held that Indian Constitution is founded in the bedrock of balance between the fundamental rights and DSP. So the next is the fundamental duties. This concept was adopted from the USSR, that is the previously held Russian government. So it was added through the 42nd Amendment in the year 1976. They were added on the recommendation of Swaran Singh Committee. The Part 4A was added for accommodating fundamental duties. So keep in mind that the Part 3 of the Indian Constitution falls directly under the fundamental rights, and Part 4A falls fun, under the fundamental duties. So originally there are 10 fundamental duties, but an 11th fundamental duty was added in the year 2002 through the 86th constitutional amendment. At present, there are 11 fundamental duties as mentioned in Part 4A, the secular state. So this the this statement states that there is no particular religion in the state of India, and each religion is given equal respect and the universal adult franchise. All adults are permitted to vote. The original constitution permitted members to vote under 21 years, but through the 61st amendment, it has been reduced to 18 years in the year 1989. And emergency provisions. So, in case of internal emergency or external aggression, there are three types of emergencies. First is a national emergency, second is a state emergency, and the third is a financial emergency. So, this articles come under 350 and 350 under the constitution from 350 to 360. The emergency provisions. The three-tier government through 73rd and 74th Amendment, a three-tier system was created. The Panchayat Raj and the municipalities were made a constitutional body. So next we come to the preamble. The preamble is an introduction of the constitution. This is a modified version of the objectives resolution that was moved by the Jawaharlal Nehru on December 13, 1946 and adopted on January 22, 1947. So initially the preamble states that only justice, liberty, equality, fraternity, but under the 42nd Amendment, three new words were added, that is the socialist, the secular, and the integrity. The Constitution derives authority from the people. With the people, is a preamble a part of the Constitution? Yes. In the year 1960, the Perrenbury case, the the Supreme Court ruled out that the preamble is not a part of the Constitution, but overriding this decision on 1973, in the case of another Bharati case versus the state of Kerala, the Supreme Court rejected the earlier opinion and held that preamble part of Constitution, and the court said that the Constitution could not be amended as to alter the basic elements. In the 1985, the LIC of India versus the Consumer Education and Research Center, the the Supreme Court held against the preamble is an integral part of the Indian Constitution. So, so these are the components of the preamble. The people of India are the source of the Constitution. The preamble declares that India to be a sovereign, socialist, secular, democratic, and republic. The preamble justifies the objectives of the Constitution: equality, justice, liberty, equality, and fraternity. The date of the adoption of the preamble was November 26, 1949, and the preamble indicates the source of the Constitution from which the Constitution derives its authority. So, sovereign. What does sovereign mean? Sovereign means independent authority of the state. It is the absolute and supreme power. This means that India has the power to legislate on any subject, and it is not subject to control of external authority. In republic, it means the head of the state is elected under Article 12 and 36 as part 3, unless the context above requires, the state includes the government and the parliament and the government and the legislature of each state and all local authorities within the territory of India. So under Article 36 of Part 4, unless the context otherwise requires, the state has the same meaning as Part 4. And the socialist, it was added through the 42nd Amendment of 1976. The word socialism means placing the production and distribution of the hands in the hands of public control. Socialism also means elimination of inequalities in income and status and standard of living. So in India, it is a democratic socialism. Here, there is an existence of both public and private sectors. This is called mixed economy. And the socialism strives to end the inequalities with equal opportunity. So the term dem secular was added through the 42nd Amendment of 1976. It means the state has no official religion. All religions in the country have the same status and support. The democratic demos means people, kratia means rule, democracy means rule by the people. The government of India elect their own representatives. In India, it is a representative society. One man, one vote is a concept of democracy. Under the justice is harmonizing the interests between the individuals and groups and the interests of the society. Economic justice under Article 39. Certain principles of policy are those followed by the state. Political justice. Each citizen is given priority in the political sphere because of this, irrespective of property and educational qualification. Each citizen is allowed to participate in the political system. Under the Article 325 and 326, it provides equal rights to all adults to participate in elections. That is the universal adult franchise. Under the liberty, it is a liberty of thought, expression, belief, faith, and worship. Under Article 19, it guarantees the freedom of speech. They are the fundamental rights. Under Article 25 to 28, the right to religion in the Constitution, the freedom of religion, including the belief, faith, and worship. Equality: all citizens are equal before the law and equal protection of law of the land. And keep in mind that there are two impacts of this statement: equal before law and equal protection of law. The equality before law is a British concept that has a negative impact, and the equal protection of law is an American concept, and it has a positive impact. Equality. So equality before law was borrowed from the United Kingdom and equal protection law from the United States. There can be no discrimination between the people on grounds of religion, race, sex, caste, matter, etc. related to access to public places and public employment. Article 14 to 18 of the Indian Constitution talks about the Indian equality, right to equality, fraternity. It means promoting brotherhood among the citizens. Article 51A, the fundamental duties, makes it the duty of every citizen to uphold and protect the sovereignty, unity, and integrity of the India and promote harmony and brotherhood. So we come to the end of the lecture. In the next class, we will be discussing the topic union and the territories.